Are we on? We are on the record.
We're on the record and in recording. Thank you.
Thank you. Let me announce the case. This is the matter for encroachment permit application number L97S-1081D. Case number PH-2022-NAV-10-002, sometimes referred to, I believe, rocks under the dock, and the applicant is Gregory Wilson. Again, for the record, my name is Karen Sheehan. I'm a Deputy Attorney General with Idaho Attorney General's Office, and I'm part of the Fair Hearings Unit. I've been appointed by the Idaho Department of Land to serve as the hearing coordinator in this case. Today's date is December 19, 2022. The hearing is set for 1 p.m. Pacific time, and it's currently about 1:03 Pacific time. We are in the Idaho Department of Land's office in Coeur d'Alene, Idaho. Again, this is the scheduled place and time for the hearing in case number PH-2022-NAV-10-002. This hearing is related to Mr. Wilson's application, again, for what I'm calling rocks under the dock. My responsibility is to consider the application and the written record, take public comment, and determine whether encroachment meets the applicable statute, rules, and case law. I am then tasked with issuing a preliminary order that will be reviewed by the Director of the Department of Lands, who will then issue a final order. I reviewed the agency record, which is also on the Department of Land's website, and I'm just going to go through the agency record. There was one additional document yesterday, which I will also add. Document 1 is the application. Document 2 is the notice of application to neighbors. Document 3 is the notice of appointment of hearing coordinator and scheduling conference. Document 4 is the Idaho Department of Land's response to request for information. Document 5 is the notice of scheduling conference. Document 6 is the notice of public hearing. Document 7 is the amended notice of scheduling conference. Document 8 is the objection and request for hearing from Falhoun, received September 26, 2022. Document 9 is the applicant's objection and protest. Document 10 is Idaho Department of Land's notice of filing, exhibits, and request for addition to agency record. Document 11 is the applicant declaration memo of authorities in support of permit issuance and exhibits. Number 12 is the order granting IDL's request for addition to agency record. 13 is the record from case number PH-2020-NAV-10-001. Document 14 is from the objector, legal memo supporting denial of application and requiring removal of encroachment, hearing statement, and PowerPoint slides. And then what was received yesterday is, I'm labeling it document 15. It's also from the objector, and it was an addendum. So I know we went through a lot of this morning, but since this is a separate hearing, I'm going to go through everything again this afternoon. So as far as presentations, first I'm going to take testimony and evidence from Mr. Wilson. Then I'll take testimony from the objector and the objector's counsel. Then anyone else who has signed up on the sign-in sheet, then the Department of Lands. Then I'll give the applicant, Mr. Wilson, an opportunity to respond to any issues and make closing remarks. Again, a few things before we begin. Please be respectful and courteous to everyone here. This hearing is being recorded, so please speak clearly. Please start by stating your name and then spell it for the record. There'll be no swearing in today. This is a public hearing for which I'm taking public comments, so all comments are directed to me. If you're a member of the general public, not a party, your comments will be afforded equal consideration. I can ask questions. No cross-examination or other questioning. I may limit testimony that is duplicative. And I might ask the presenter to remain on task if they begin to wander. And presenters may always defer to legal counsel or specialist. So again, if anyone wishes to submit written comments, please submit them after their presentation or when I call on them. Written comments will be given equal consideration, and any written comments must be received by the end of the hearing. So any comments about the process? So with that, Mr. Wilson. Thank you.
I wanted to just cover the exhibits that you did. Did you receive my response to IDL's reply for information to you? I filed it yesterday, Sunday.
So I announced that this morning. Did you file one for each case?
Just for this case.
Oh, I apologize. I made that part of the record this morning. So I will have that deleted from the record this morning and I will make it part of the record.
It only applies to this 1081D application.
Okay. So noted. Ms. Wilson, do you want to go ahead?
Okay. So this matter originated because about 10 years ago, my son and I had placed some cobblestones in front of our fixed pier bulkhead. By bulkhead, I mean the concrete, the outboard concrete foundation that is closest to the dock. We did that principally for the purpose of assisting Deborah and I lowering and raising the ramp when we moved the ramp in the fall for winter storage on top of the dock and lifting it off and attaching it in the spring. So it has a pretty limited use, but it's a necessary use. In those past years, we had a Trex decking on top of that and it was pretty heavy. So we switched to and put what's called flow through to lighten the load, but it's still pretty heavy. And it's awkward. So that's really was the purpose of it. So on July 8th, Mike Gamer sent me a letter as part of a denial letter for the log structure for application 1081C. He asked me to remove this, and I discussed it with him. And ultimately, in order to avoid a non-compliance letter, I filed an application to permit it under Idaho Code 58-1305A, which speaks to the enlargement of aids in navigation, which includes piers. So this was termed as a pier extension amendment to my 1081B permit. So with that filed, went through a couple of drawing revisions. There were 3 drawings. Originally, first drawings included the log crib with his stones on it. Ryan said I had, Ryan said I needed, Trevor said I needed to Ryan said I needed to remove that. Excuse me, I am crossing up my cases already. So the permit that was filed in August of 2022 was an enhancement of the permit that I had received in June of 2021. It sought to permit the rock structure, the cobblestone pier extension in front of the pier bulkhead. My wife and I met with Mike Gamer mid-September, September 21, after we received approval of the application and it had been completed. We met with Mike to try and argue that this really wasn't a non-navigational function. It was a navigational function because it was a pure extension. He disagreed. We spoke about proceeding under 1305, the navigational encroachment permit process. And he said, well, we're going to have to argue that this is a most unusual circumstance, which is language that's contained in 1305. Just says if you're doing something that's unusual, we're going to object. And that's what I had expected. In fact, I had expected it so much that I told him I need more time to prepare the case. I have to hire some experts, like a geomorphologist and others. And I said, I will waive my 60-day time clock so that I have that. So you will probably see some waivers in the file, and it was to that purpose. Well, what became obvious to me is when I received a copy of the notice of appointment, on October 4th, I noticed that this navigational encroachment application is going to be processed under Idaho Code 58-1306 C, B, and C. So I was a little surprised. And my principal concern here is that altering the process for this application from 1305C to a 1306C makes it virtually impossible for me to defend my navigational property. I have a protected property right in aids to navigation. I filed the application as a 1305 application. It was reviewed by Ryan Sandhausen as such, supplemented a couple of times, and I finally determined to be completed 15th of September. Each time I think it was sent up to Mike Amer. And I don't know what happened during that week. We met with him on Wednesday at 2 p.m. here. And we're under the distinct impression everything was fine. We're going to proceed to go under a formal proceeding. And they switched it. They switched to 1306 because of the appearances of this. So my trouble is, you're going to accept my application and my filing fee for a NAV app permit and you deem it complete. You just need to proceed under the process of 1305C if there's going to be some kind of a dispute. You can't just automatically change that process. And I think in my principal argument in my briefs is that this is a prima facie violation of my 14th Amendment right to due process. You know, and the Newton case pretty much outlines what has to happen in the state of Idaho to prove that. You have to prove that you have a protected property interest. Well, Newton didn't, but I do. I have a protected property interest because the LPA says, since I'm a littoral owner, that I have a right to access the adjacency of my ownership and make use of navigational aids. And when you take my navigational application and convert it into defending it as a non-navigational application, you violate my right to constitutional due process of law. If they didn't like my application, initially it should have been rejected, but it wasn't, it was accepted. And so there's a classic case of procedural due process violations. I have a property right, use the wrong process. I should have been processed under 1305C. I wasn't. And this is really important because a 1305C hearing is a formal adjudicative proceeding where I have trial-like rights. Witnesses are sworn in. We can direct examine under oath, cross-examine, because you're defending your property right that the LPA grants to me. By putting me in the forum where I'm now in an informal proceeding like this today, I don't have any of those judicial tools available to me. None at all. And I'm having people attempting to take away that property right by making me defend it in the wrong forum. I get it. They didn't like what I did, but you got to play fair and play by the rules. Argue most unusual circumstances. It might be tough for me to defend that, but that's the right forum to be in. And that didn't happen. So that's really my principal argument here. Secondarily, you're going to put me in the wrong process. You didn't even do that right. There was no notice of application published in Bonner County. 1306. He says you got to do that. You know, you've got to give the public notice that I have of this information in the application so that the public has 30 days in which to comment or object. They didn't do this. If you look at the procedures that were followed in the hearing statement, a glaring omission is we didn't publish a notice of application. The guidance document says And it's not law, but it says you need to publish the notice of application, then you should produce an affidavit of publication for the hearing. This is on their checklist. Do all these things before you get to have a hearing. That wasn't done. You know, we went around a little bit with that when you had requested Ideal's counsel to provide an analysis on whether we're proceeding under the correct statute, 1305 or 1306. And her argument was it's proper to proceed under 1306. And because they claimed an exception to publishing a notice of application, that exception is for a director ordered hearing. The argument that was put forward, I think verbally, was that Mr. Amer, on behalf of IDL, made a decision to call for a hearing, and that quote director order was represented in the notice of appointment and scheduling conference that was noted up on October 3rd. I disagree. And in my brief, I talk about what an order is. You know, an order can only be issued by a department head, and that's Mr. Miller. Anything from anybody else is a preliminary. And Rule 701 speaks to that pretty clearly. So Mr. Amer didn't make a direct order. IDL didn't publish the notice of application, and he missed a major procedural requirement. This prejudices me because I should have had more public support. And by failing to do that, I've been deprived of that public support, and the public's been deprived of notice. You don't get to hold this hearing. You don't follow your rules. And that's pretty much it. You know, I made some other remarks in there that you can read. I don't think I really want to speak to them publicly, but they're important. There are some important considerations. There's some really unanswered questions. But when Deborah and I met with Mike on Wednesday, there was never a discussion about switching the procedures on this one. Not one bit. Or I wouldn't have waited the 60-day requirement and be thrown into a 90-day requirement. So they missed the notice of application. And they're really on top of that. Like, this is the icing on the cake, I suppose. This wrong hearing is not even being held within the 90-day period. Today's day 94 from when the application was accepted. And it says here in 1306, you got to hold it in 90 days. So this hearing missed a very important procedural notice to the public and didn't hold the hearing within 90 days and had my constitutional rights violated by switching the procedures on it. And it's all wrong. I mean, this is it's just wrong. Now, what should have been done? Well, this should have been a 1305. And under 1305, IDL's got 60 days to process my application. And if they don't process it in 60 days, it's deemed approved as a matter of law. Idaho Code 58, 1305, subparagraph G. That's the remedy here to avoid constitutional violation and other statutory violations. My application should be deemed approved as a matter of law. And the rest is in my briefs. The one that I submitted on Sunday was really designed to be a response to what IDL submitted to you on October 21st for your guidance when you asked whether 1305 or 1306 is proper. So I've gone through the IDL guidance document, which is really a fabulous piece of work. It's extremely clear. And use that as the basis to argue the procedural defects, which in my opinion, divest IDL of jurisdictional authority because they violate the statutes and the 14th Amendment of the United States Constitution. That concludes my remarks.
Thank you. Ms. Regina.
I can't. Oh, sorry. Mick, could you please let Michelle Fulgham be a co-presenter or present or share screen?
Certainly will stand by.
So how do you say your last name? I had it from the last time that it should be with a J or is it with a G?
It's basically with a J, full gem.
Okay, that's what I was trying to fix both of these. I even have this right here. Okay. Thank you.
Not a big deal.
Are both of you going to speak?
Sure, but he can go first and
Okay.
do the slides. I just had to be ready for that.
Okay, Ms. Fulgham, give it a try.
Is it sharing? Coming through?
It's not yet.
Jennifer converted it to a PDF, so it should be faster now.
I can verify that she has co-host permission, so let's just see. Maybe it has to do with the IDL's Michael's office blazing fast internet speed. I'm sure that's part of it.
Ooh, it's not pulling it out this time. I'm gonna log out and log in again. Do you want to go ahead and start? Then I'll.
I do have them in hard copy too, so.
Yeah, so go ahead and start.
Well, and I can, I believe if it's a submitted document on the page, I can open it up on my end. Is it but all I have is PDF. Which one is it that we're talking about?
It's the objector memo hearing statement PP 002.
Just the PDF. It's only 17 pages.
So that you see what I'm talking about.
I think I have it open right now.
Okay, thank you, Mike.
That's, I think, the hearing statement.
Could you go farther down?
I think it's the back of it.
Yeah.
Yeah, it was kind of all worn in
I
on.
think it was page like 7.
70.
Yeah, it started around 70, 72, something like that.
There you go.
This?
It should be the next page.
Yeah.
I think you might be able to use this.
And just pointed it back.
Well, you have to just put the cursor onto the next page, or you could just scroll down.
Got it.
Hey, folks, stand by while I now I've added Mike as the co-host. I want this to be able to be recorded. I hope you all don't mind a little bit of patience.
Okay.
I guess that was my direction last week, that the PowerPoints would all be recorded on Zoom. I don't think that's on your.
Right now, we're bringing Ms. Fulgham back in. And Mr. Amer has shared the screen, so we're good on my end. Thank you, folks, for the patience.
Do you see it going up and down, Mick?
I do, sir.
Okay.
Thank you.
We'll use that.
Okay. This is Bill Falloon. It's F-A-L-O-N. On September 20th, 2022, I received a letter from Brian Zanhusen of Idaho Department of Lands. He sent a letter to the neighbors of Wilson's. They applied for a cobblestone extension under the approach and ramp to their dock. I'm calling it a jetty because what we learned from the previous hearing in December 2020, the jetty is a structure that extends into a sea, lake, or river and to influence the current or tide or to protect a harbor. Anyway, I objected to the application. And as I went through the Wilson's application, you can see a few things from just going through the pictures of F1. This picture that Wilson submitted for their permit. And so the jetty, I call it, under the approach and ramp to their dock. But they also submitted, let's go to F2, a picture of their proposal and from 9/20/2022, and it shows that the jetty, the rocks are underneath their rim. You go to F3. This is just a magnified picture of one of the pictures in F2. Shows that the distance between their fixed pier and their dock is 6 feet, and shows what they call a cobblestone extension. If you go to F4, you can see the side view they provided in their application. Again, shows a distance of 6 feet, the cobblestone extension from their pier. This is fortunately the picture that was in F1 wasn't in my opinion, a true depiction of their jetty or cobblestone extension. This picture F5 is a picture of their cobblestone extension jetty, whatever you want to call it, when the lake level was down. And in December 1st, 2021, the Wilsons described the size of their jetty as being 6 feet long by 2 feet wide. My estimate is much larger than that. I estimate that their ramp going from their approach to their dock is approximately 12 feet. Estimated the length of the jetty to be approximately 10 to 12 feet by 4 feet wide, and height is approximately 2.5 feet high at the end closest to shore, and then narrows as it gets in the lake. You go to F6. F6. This is another picture of their jetty. This was taken in July of 2021. Again, it shows the size of the jetty. You go to F7. This is just a picture of their dock and the ramp and the approach. I'm going to go back to F7. And again, it also shows the jetty underneath it. It also shows what I described as the concrete wall that goes from the support pillar that's in the lake there and to their other support pillar on their shore, which is not seen in this picture. Now, if you go to F8, this picture is again of that concrete wall, and it has some what I call parallel rocks next to it. And if you look, it extends again from the pillar closest to their boathouse up to the end of their approach. And if you look, you sort of see the sand height difference between underneath their approach and to the south, or where their beach is, to the right of it. Anyway, when you go to during I'm going to skip around here for a little, so excuse me. And in F9, you can see that what is causing, what's happening is again with all jetties, sand cumulates to the north and is eroded to the south, as you can see there. And if you go to F10, again, just depicts what we've described before, a property line, but also a barrier to the north is causing sand to accumulate to the north and erode to the south. And again, the purpose of the jetty is not intended to it is intended to stop erosion and hold sand sediment deposited north of it. If you go to F11, this was a picture of the Wilson's prior dock when they purchased their cabin. This is taken approximately 2003. They had a previous dock, and if you look, there's no jetty, cobblestone extension, whatever you want to call it, and I don't see any cement wall or parallel rocks there. So there's a distinct difference between the 2003 and currently when they replaced this dock with their current dock. In their permit that they're granted for their new dock, their current dock, you go next. Yeah, that's well, this was on March 2nd, 2004. This picture, F12. That's when their current dock was granted, and they granted a fixed pier, which is 4 feet by 20 feet, a ramp that was 4 feet wide. There are different descriptions of the length of it in the body of the application. It said the ramp was 7 feet long, but then up on the upper right, upper left corner, it says ramp 9 feet by 4 feet. And then if you look at the diagram of the ramp, on the ramp diagram, the ramp says that it's 12 feet by 4 feet. So I don't really know, the ramp was either 7 feet long, 9 feet long, or 12 feet long. It says 3 different things in the application. Anyway, the floating dock is 8 feet by 45 feet, and with a 10 by 12 foot extension and a boat lift. But there's no jetty there. There's no rock barrier underneath their ramp or their approach. Anyway, in there, you go to, let's see,
14 shows no jetty.
go to 13, please. I'm sorry. 13. This was when it was granted. It's difficult to read, but under what's circled in red, number 2, it says the permit does not convey the state's title to or jurisdiction or management of lands lying below a natural or high water mark. So they did not have a jetty there, and they weren't allowed to have jurisdiction or management of lands below the natural high water mark. I do want to make a point. The ordinary high water mark is 2,437.64 feet. You can think of Priest Lake as a bathtub, and it's 1 point. It does not vary from place to place. It is 1 point. It's an elevation. It's around the lake. If you can find that point, Coolin, or at my property, or Greg's property, or whomever. It's a fixed point. It does not vary. from place to place, so or vary because of seasonality or wet water level, so it's a fixed level point. But in the Wilson's application, in my addendum that I submitted yesterday, they said that the Wilson's proposal, the purpose of it is to, number one, to continue to block 16 to detail each work activity and overall project. We discussed this earlier this morning. Once again, it was the Wilsons own lot 16, I own lot 18, so they wanted to block their own work on their lot 17. Then it says, they said, the cobblestone extension of the applicant's dock pier is an aid to navigation. The extension is a sloping 6-foot extension of the applicant's existing pier / dock encroachment permit. The extension serves as a support structure of lowering and raising the pier to dock access ramp. The ramp's weight rests below the end of the pier on the stones, supporting the ramp during periods of seasonal ramp detachment from the pier. Well, that's really not correct, in my opinion. First of all, the ramp, the Wilson's ramp is actually relatively lightweight, and it's very easy to detach and detach and attach to their approach. It also has wheels on the end of it that rests on the dock, and it makes it easy to slide the dock, slide it onto the dock. And it was so easy that I actually purchased one, haven't put it on. It was much easier to put on and off than my current approach. The rocks do not help in putting the ramp on and off the approach. It actually is a detriment to it, and it makes it more difficult to put take the ramp on and off, because you have poor footing underneath it because the rocks are in the way. And also sometimes you have to walk underneath the dock, underneath the ramp, and the rocks actually impede you from doing that. It's as the Wilsons have done for many years, as universally everybody on the lake does. You simply detach the ramp and you slide it onto the dock. Then you reposition it in the spring or early summer. They've never put it on the support to rest it on there, and it would probably in fact cause more damage to the ramp and the dock due to motion of the lake as the lake level rises, or the wind, or heavy snow load, or other weather conditions. Anyway, I'll go to the orthopedic evaluation of it. You can read that yourself. In addition, it says that the on page 5 in the Wilson's permit, it said the detailed description of each activity within the overall project. It also said the pre-existing cobblestone extension is approximately 2 feet wide and 6 feet long. The stone support structure is situated underneath the pier, the dock ramp. I'm sorry, the pre-existing cobblestone extension is approximately 2 feet by 6 feet. Well, it was never pre-existing before 1975, and it was created after 2004 when they put their current dock. And their current dock built. Now if you go to next picture. Again, this is a F-15. The side view that Wilson's put in their application. Again, it shows the the two concrete piers that were, as I said, existing. Doesn't show the concrete barrier or concrete wall between the two pillars. Two piers rather, and it doesn't show the jetty or cobblestone extension. Again, this was taken in March 2nd of 2004. Go to next. F-16. This is when the Wilsons their permit application for the area at the southern border that we talked about this morning. And it doesn't show it, you can see their dock there, and it doesn't show a cobblestone jetty underneath their approach. I guess I'll let Michelle talk about but legal action, legal determination, but jetties and bank barbs are generally not be permitted as a method of controlling erosion. I'll let her talk about that. We go to next picture 17. Here's go to 17. Sorry. This is what we talked about briefly. This morning, I had a permit done. This again is my property line with the Wilsons. The blue flag is the high water mark. Again, you can go to F-18. The Wilsons have not determined, or excuse me, before I get to that, on June 29th, 2022, Brian Zanhusen went to the Wilson's property, and as we discussed this morning, he evaluated both the barrier of our property line and under their dock, or excuse me, under their approach, and he documented that rocks underneath the Wilson's pier were also observed below the ordinary high water mark. Logs, the rocks, and the charts are unpermitted at their property line. Anyway, you can go to the next. This is my estimate. This is only my estimate. So of approximately where the high water mark would be at the Wilson's property, but it's not been determined. On July 8th, 2022, Mike Gamer wrote Wilson's telling us that both that the rocks and presumed concrete have been added underneath your pier and approach ramp dock. The rocks are not permitted, applied for, and would constitute a non-navigational encroachment that would need to provide a significant benefit to the public or of Idaho via economic, social, or environmental purposes. Please remove the rocks within 30 days, approximately August 12th, 2022. They could also, I guess, apply for a permit or anyway, again, it said apply by August 12th, 2022. Going to notes that I got from Mike Gamer. Brian Zanhusen of Idaho Permanence at Priest Lake did not receive their permit application until September 14th, over 30 or a month after the deadline of August 12th. Conclusion, the barrier, the jetty cobblestone did not pre-exist before 1975. It was built after 2003 doesn't benefit the general public's environment, economic or social, or have any environmental, economic or social benefit. Detrimental because it causes erosion. Our beach causes it's detrimental to the aesthetics, use, property value, property. And previously, Idaho Department of Lands had deemed that it was not allowed. It should be removed by August 12th. That's it.
Ms. Fulton?
Thank you. I'll start with the application itself because I think it'll save some time where we don't need to go off on tangents that we don't need to deal with. The applicant, as an attorney, has argued or attempted to argue questions about the jurisdiction of IDL over this application. And we really don't need to get there because we can take the applicant's own words, their own representation. F2 clearly depicts this application is for cobbles below the ordinary high water mark. We don't need to fight about where that is. We don't need to fight about measurements. The applicant is telling us in an admission through exhibit F2, this is below the ordinary high water mark. As a matter of law, that is Idaho Department of Lands jurisdiction. End of discussion. The Idaho Department of Lands permitting requirements govern this application. It's a non-navigable encroachment. And we've heard the applicant argue a lot about due process and technical, constitutional, legal arguments, but he also said, if they didn't like my application as a navigable encroachment, then reject it. Had they done that, we would be hearing due process objections. We would be hearing, you failed to give me my hearing, you failed to give me my notice, it's a red herring. There's no legitimate argument for the applicant to say, if you don't like my application, reject it. No, you have to go through the process. The counter people taking applications don't get to make substantive determinations and reject it. And it's really disingenuous to say that would have been an acceptable solution to this applicant. I think we know from the tenacity and the numerous violations that have been flagged, that would not have been the end of it. So IDL properly makes a determination that it is a non-navigable application and processes under the correct governing statutes. Again, I think the applicant's words come back to haunt him because we had conferences with the hearing coordinator, and Ms. Romine was setting a hearing in this case. I believe it was for October. There was a date, and she was setting the hearing. I mean, this application wasn't stamped complete until September 25th. And she was setting hearings in October. And the applicant said, no, that's too soon. I need lots of time. I reject that prompt hearing that Ms. Romine was setting. I need more time. And then we went back and forth on dates, and this is the date. And all counsel were available on all parties. So again, I point out this inconsistency because it's unfair to say IDL missed deadlines when the applicant didn't have a counter complete application until September 25th. And then the applicant said, no, I don't want the hearing date as soon as Ms. Romine is trying to set it. I want a hearing date later. Can't have it both ways. And there has not been a missed hearing deadline. The applicant did not want to proceed the faster hearing that Ms. Romine was suggesting. A legal brief that we filed sets out the statutory authority, sets out that just like the previous encroachment that was lawfully constructed without a permit, this is a bank bar. It's a jetty, and these are not allowed. It looks exactly like the previous one that was denied. Rocks are going perpendicular to the shore, and it provides no navigational benefit. That one was properly denied, still hasn't been removed 2 years later, and this one should properly be denied as well. The statutory authority, Dr. Falloon shouldn't bear the burden of documenting, gathering evidence, and seeking enforcement of IPL's rules. He's done a huge amount of work based upon repeated, documented, and proven violations. And what the legal brief submitted is requesting, not only is this permit not a navigational permit, and not only is it not a proper non-navigational permit, but it should be denied any permit at all. And we request that a mitigation be ordered. He's for 2 years, he has to continually keep coming back and asking IDL. You denied him his permit after a public hearing and thousands of dollars in legal fees in 2020. And we sit here today looking at pictures, it's still there. No removal, no remediation. 2 years later, even though he filed his lawsuit and he dismissed his lawsuit, waiving any and all claims arising out of that, it's still there. Same with this. Was built without a permit, which is illegal. Have to have a permit before you begin the work in the IDO encroachment area. And now we want the permit denied, and pursuant to Idaho Code 58-1309, we want mitigation. We want it removed. And I disagree with opposing counsel Ms. Kaufman a little bit, because what that statute says is that the LPA authorizes an order requiring the applicant to restore the lake to as near its condition immediately prior to the unauthorized encroachment as possible, or, and this is the key that we want from this hearing examiner, from the director, or to effect such other measures as recommended by the board and then ordered by the court toward mitigation of any damage caused by or resulting from the unlawful encroachment. We've got multiple unlawful encroachments. We've got the one from 2020. We've got the log crib, which clearly has been modified since 1975. That's an unlawful encroachment. And now we have this unlawful encroachment that was built without a permit. And it's unfair to require Dr. Falloon to keep coming back year after year after year, month after month. He's not an attorney like Mr. Wilson. He can't do this on his own for free, for sport. We want IDL to enforce the regulations, deny the permit, and then, quote, effect such other measures as recommended by the board. And that measure under the statute is remove it and mitigate the shoreline and put it back. And so because I think IDL did a good job in their briefing of documenting there is no public benefit, council doesn't claim there's any public benefit, the evidence really warrants factually and legally the denial of this permit. There's no public benefit. Nothing for navigation, fish, wildlife habitat, aquatic habitat, recreation, aesthetic beauty, waterfall. None of those things are established and proven by the applicant, nor are they really even alleged or asserted. So because it fails to meet the preponderance of the evidence statute, which we cite in our brief, it's more probably true than not. There isn't a preponderance of evidence established in the record supporting approval. In fact, the preponderance of the evidence warrants denial and we request removal. Is there something else you told me I was supposed to cover? I thought you said Michelle's supposed to cover that, and I made a note and I forgot what it was. But if there's any questions, I'm happy to address them.
Thank you.
Do I say one more thing?
Please go ahead.
In the hearing. December 2020. Was held similar to this hearing. Greg and his representative spoke, I spoke, and Michelle, that Greg had the last word. But this is quoting Greg, says, I don't want to think that Bill caused me all these problems finding these little issues. I mean, we've played tit for tat here, you know. But he's doing it to me by complaining about under my dock, there's a little protrusion which wasn't there. You're right, it's not. I'll permit it. If that's what it takes, but it's so small, it makes no difference in the greater picture of life on the lake. But if you guys want me to pull this thing out, he's referring to the barrier, property line, just give me some place to put it, because I'm not hauling it up the hill. And I will spend untold sums of money to defend it if I have to go the grandfather route, because the property is valued at $2.5 million. That's what I'm dealing with. I don't have, he's probably wealthy than I am, I don't know. But just like Michelle said, I'm not an attorney. He does this. I've done literally nothing for 2 years. And the only person that's getting adversely affected by this is me and my beach. I'm the only person. And he plays this game that he keeps on, you know, all these things. It's just time to resolve this issue. I've done nothing. Thank you.
Thank you. So I've looked through the comment sheet and it does look like Deborah Wilson, if you want to, are you Deborah?
Yes,
I thought so. Did you also like to say something?
Yes, I would.
Please go ahead.
First off, Dr. Falloon's assumption on the usability of the rocks that we use to raise and lower our ramp. Maybe it's easy for him, but it's not easy for me. I'm 5'4", 68 years old, and that thing is heavy. And the way Greg and I have managed to put it on so we can access our dock and the lake is by building a little support so that rather than dropping the entire distance to the bed of the lake, we can do it in stages. And even with that, for me, it's heavy. And if you look at that, if you look at the width of the dock and you look down, you don't even see any rocks. It's all within the footprint of where that ramp lies. Other thing I would like to say is that what he calls concrete wall, that has absolutely always been there. It was there when we bought the property. You know, to build something like that, I noticed that you'd have to get forms. I mean, concrete work is not something that goes unnoticed when you're building, but I could just swear that it is absolutely, it has been there. And I do understand that when people are doing these diagrams for permits, they don't put every single thing in there. You don't put your nails, you don't put your planks, and having a straight line drawn there to me does not seem out of the ordinary. The other thing I would just like to say is, Bill, I disagree with some of the things you've said that I have said and that Greg has said on the beach.
Ms. Wilson, you have to direct everything.
Oh, I'm so sorry.
That's okay.
I'm sorry. My mistake. it's not actual. It's not accurate. It's taking a conversation and then months or years later saying, well, they said this and they said that, and our perception of that is very different. So I do disagree with that. And I also wonder why all these photos of our property, you know, that it just makes me uncomfortable to see how many photographs he's taking of our beach. I mean, my girls are out there on swimsuits. I don't, no, it's not this case, but that I don't understand the obsession with taking photographs of our property. And that dock is what do you think, Greg, 50 feet from, how far is that? About 50 feet from his boundary. I don't get it.
It's,
They respond to anything or not?
it's not.
Oh, okay.
Anything else?
That's all, thank you.
I'd like to take of course, I knew if I took the other binder out to the car that I would need it, and because I want to just briefly look through your memorandum one more time before we finish everything. So I think maybe the best time to do it is just for me to run out to the car right now and get that memorandum. So let's just take a 10-minute break. I'll just note it's 2:03. So we'll reconvene at 1:15.
All right, I've paused the meeting. Yep, we started recording again, Ms. Hearing Officer.
Thank you very much. So when we, before we took the break, we were about to move on to Department of Lands to give a statement.
Sure. And I'll just start out and hit a few of the legal points, and then I'll turn it over to Mr. Amer to present a statement on behalf of the Department of Lands. So on the issue of procedural due process, fundamentally and overall, the Idaho law is clear that procedural due process is fundamentally notice and an opportunity to be heard. The applicant has had that here. Applicant may disagree with whether this is a 1305 encroachment or 1306 encroachment, but he has fundamentally been given the opportunity for notice and the opportunity to be heard, which is what we're doing here today. Even more fundamentally than that, littoral rights, which are really the rights at issue in these proceedings, are the right to maintain adjacency to a navigable water body, and subject to state regulation, the right to wharf out. And that subject to state regulation language, I think it was first in a case known as Lake Coeur d'Alene. More recently, it was in Newton. It's found in Newton versus MJK BJK LLC, which is 167 Idaho 236, 469 P323 from 2020.
Sorry, it's 167 Idaho.
Sorry, 236.
I know it's been referenced a few times today. Thank you.
And what we're talking about here isn't any sort of impingement on the right to wharf out either, and there's no sort of impingement on the right to maintain the adjacency. What we have here before the hearing officer today is an unpermitted encroachment. There's no property right in an unpermitted encroachment. We're here today to consider whether it should be permitted, but it's not permitted. There's no property right in it. I would also note that the rock crib, it's not a crib, the rocks are located primarily below the ordinary high water mark on state-owned public trust land. This is not on private submerged lands owned by the applicant. This is below the ordinary high water mark, and therefore on state-owned land, and it's held in trust for the public. Finally, as to the notice, I'll note a couple of things. First of all, The notice of appointment of the hearing officer and scheduling conference was issued on October 4th, 2022, clearly indicating that this was going to be processed under Idaho Code Section 58-13-06. Applicant has had more than 2 months to find people who would testify, whether members of the public or otherwise, who would testify in support of this application. I also note that, as Mr. Amer states in his hearing statement, this notice of this hearing was published in the Bonner County Daily Bee on December 3rd and December 10th, 2022. So the public was given notice of this hearing, was fully able to show up, testify. Mr. Amer tells me that he received absolutely no phone calls about this application. And I would also note, to the extent that the applicant is objecting now on the basis that this hearing is held 94 days from the date his application was final, he agreed to this hearing date at our pre-hearing conference. And initially, when Ms. Romine was trying to set up the hearing as soon as possible in October, he said he didn't know when he'd be available and for a hearing. So, you know, IDL has noticed this appropriately and in accordance with Idaho Code Section 58-13-06C, provided notice of the application and notice of the hearing date, published those for 2 weeks, 2 consecutive weeks in the paper of record. They provided the applicant with an opportunity to be heard here today, as well as the agenda. So with that, I'll just turn the time over to Mr. Amer.
Before you do that, do you have a statute or case reference to what you argued the procedural due process basically is the right to notice an opportunity to be heard? And maybe we could go ahead with his testimony while you look that up.
Thank you. Before I begin my statement, I'd like to make three points. From earlier this morning and also from this afternoon, I'd like to point out that it appears through numerous photos from Mr. Flynn's testimony that the ramp is still attached to the pier and to the dock. There are several photos taken when the water is low in the wintertime in December that show the ramp connected from the pier to the dock. I'd also like to point out that it's brought up this morning and this afternoon as well, as far as the 90-day notice. And if we haven't had the hearing within 90 days, then it should be approved. Under Section 30 of IDAPA, under the section for the hearing, it states notice of the time and place of public hearing on the application will be published by the director once a week for 2 consecutive weeks in a newspaper in the county in which the encroachment is proposed, which hearing will be held within 90 days from the date the application is accepted for filing. There's no term of shall, which in our world definitely means that something has to happen. It also does not say that if it happens after 90 days, it's approved. I believe that's kind of been alluded to a couple times today. There's nothing in that section that says it will be approved if the hearing doesn't happen within 90 days. The last point I'd like to make before my statement, photo F5 from Mr. Flynn's testimony today clearly shows that there are many rocks beyond where the ramp would rest after disconnecting from the pier. There are also a lot of ramps underneath the overhang of the pier. I feel that when you take those extra rocks along with the logs we discussed this morning, plus the jet skis, plus the Hobie Cat, plus the sandbags, it appears the Wilsons are clearly trying to manipulate sand flow on their beach. With that, I'll read my testimony. And as I did this morning, I'll just start at the conclusion section since the testimony is part of the record. Applicant is seeking to permit an existing rock structure underneath the fixed pier of a single-family dock to support the ramp during installation and removal. Applicant is requesting the application be processed under Idaho Code 58-13-05 as an aid to navigation and part of an extension of the fixed pier. However, the rocks are fill and more closely resemble a non-navigational bank barb or jetty and should be processed under 58-13-06. I will address the rock structure and IDL's analysis of the applicable rules for both 58-13-05 and a 58-13-06 encroachment type. 58-13-05. If one were to assume the rocks underneath the fixed pier are an aid to navigation as applicant claims, There are still sufficient concerns regarding the rock structure that IDL believes should result in a denial of the application. In my 8+ years working for IDL in the navigable water program, I have processed thousands of encroachment permits for single-family docks and performed hundreds of inspections throughout the lakes of northern Idaho. I have never seen rocks placed underneath the pier to assist with the removal or installation of the ramp. The quote-unquote formula of a fixed pier, ramp, and floating dock is extremely common on all northern Idaho lakes, with the exception of Lake Pend Oreille, which has a primarily fixed piers due to the 11.5-foot elevation change related to the Albany Falls Dam. It is relatively common for floating docks to be stored somewhere sheltered and safe for the winter, for docks to be pulled up on shore or out of the water in non-summer months, or for the ramp to be removed and placed on the fixed pier or floating dock as the angle is too steep. When the water level drops, the floating dock portion lowers with the water level. The ramp increases in steepness as the fixed pier remains at the same elevation. I have also helped and assisted numerous older waterfront residents that are age 70+ and have never once heard of anyone having the issue with their ramp and needing to build or install a structure to assist in the ramp storage process. Based on photo evidence provided to IDL from adjacent neighbor Will Falloon, IDL believes the rocks were installed sometime between 2003 and 2018. The date installation means there's no way the rocks were placed before the Lake Protection Act came into effect January 1st, 1975, and thus could be permitted as is as a pre-LPA encroachment. Therefore, the rocks must meet the current rules, regulation, and standards for a single-family navigational encroachment. IDL does not authorize or allow crib rock structures, concrete cube piers, or fill out into the lake to create a pier structure. When it comes to fixed piers as part of a floating dock system, IDL would only allow the typical fixed pier consisting of decking on top of framework supported by pylons, or similar to what applicant currently has in place. Although the footprint of the rock structure falls directly under the footprint of the fixed pier, it is additional fill material that restricts sand flow and water movement. Testimony from the previous hearing for the rock jetty, which was PH-2022-NAV-10-001, showed that rocks extending below the ordinary high water mark trap sand on the north side, enhancing applicant's beach. This does appear, however, to reduce sand deposition on the south side of the barrier and induce erosion of Mr. Falloon's beach. As noted in item D.2.C of the conclusions of law in the preliminary order, the intent of the Bank Barber jetty and the Wilson Falloon property line was to hold the sand and sediment that is artificially deposited north of the pre-existing crib and the unpermitted existing jetty. Variations of this statement are repeated in items D.2D and D.4.A of the conclusions of law for the preliminary order. While the rocks in the current application are not on the Wilson Falloon property line, they are interfering with the general distribution of sand on applicant's shoreline, and those effects may extend to the Falloon property and beyond. If processed as an Idaho Code 58-1305 application, IDL recommends denial for the following reasons. With over 8 years of experience processing thousands of encroachment permit applications, performing hundreds of site inspections throughout North Idaho, and never coming across this request or seeing rocks used in this purpose, makes this proposed application an extremely unusual circumstance. The fact that there are thousands of other waterfront owners with a similar dock setup as applicant proves there are other alternatives to achieving the same goal as applicant without the need for a rock structure. Something such as a folding ladder or a sawhorse or a wood plank would appear to work. Photo evidence proves the rocks were installed after the LPA came into effect, and IDL would not permit or allow a rock structure to be used as a fixed pier under our current rules, regulations, and standards. Finally, the rocks impede sand flow and shoreline drift. There's been an ongoing contentious battle between applicant and adjacent neighbor Falloon over sand flow restriction. 58-1306 encroachment. IDL strongly believes the application is more in line with an Idaho Code 58-1306 encroachment type related to non-navigational encroachments. The existing rock structure is not a pier extension as stated in the application. The term pier is not defined in IDAPA, but it is included in the list of encroachments in aid in navigation. Pier is defined in the Merriam-Webster dictionary as a quote structure such as a breakwater extending into navigable water for use as a landing place or promenade or to protect or form a harbor, unquote. Black's Law Dictionary defines a pier as a quote structure extending from the solid land out into the water of a river, lake, harbor, etc., to afford convenient passage for persons and property to and from vessels along all sides, end quote. Oxford English Dictionary defines a pier as a quote, platform supported on pillars or girders leading out from the shore into a body of water used as a landing stage for boats, end quote. None of these definitions suggest that the applicant's proposed use of supporting the ramp during periods of seasonal ramp detachment is part of the pier or pier extension. As stated above, in my 8 years working for IDL, I have never seen a request such as this claiming to be an aid of navigation. IDAPA 20.03.04.010.15 states in part that encroachments aid in navigation are used to, or are quote, used to support watercraft and moorage on, in, or above the beds or waters of a navigable lake, end quote. As stated above, the common formula for a dock in North Idaho is a fixed pier, a ramp, and then a floating dock. The fixed pier portion allows a property owner the ability to walk from shore out into the water to access their dock. The ramp portion allows a property owner to be able to gain access to the floating dock as the ramp steepness fluctuates with water levels. The floating dock portion allows boat moorage in sufficient depth of water. All three components are part of a single family dock and are all aids to navigation. The rock structure underneath the fixed pier does not aid in the support of watercraft or moorage of a vessel. Additionally, the rocks do not support, hold up, or stop erosion on the fixed pier. As stated in the application, the rocks simply serve as support for the applicant when installing and removing the ramp in the shoulder seasons. As discussed earlier, the rocks proposed in the application do not meet the definition of a pier or pier extension. The rocks appear to be a bank, barb, or jetty. The photo submitted with the application shows that the rock structure tapers vertically as it projects into the water, similar to the definition of a bank barb in IDL's encroachment procedures. The landward side of the rock structure is higher than the waterward side. If applicant truly wanted to have a support structure to rest the ramp during installation and removal, wouldn't it be easier and more conducive if the structure was flat and level as opposed to tapered and sloped? IDL's encroachment procedures in regard to bank barbs state jetties and bank barbs shall generally not be permitted as a method of controlling erosion on lakes and slack waters of reservoirs administered by the department for trust purposes. These type of encroachment could have adverse impacts to navigation and recreation. As stated in IDAPA 20.03.04.030.02, encroachments not in aid in navigation in navigable lakes will normally not be approved by the department and will be considered only in cases involving major environmental, economic, or social benefits to the general public. Approval under these circumstances is authorized only when consistent with the public trust doctrine and when there is no other feasible alternative with less impact on public trust values. The application does not meet this standard and should be denied. No public benefit has been identified. This is why jetties and bank barbs are generally not permitted by IDL on lakes. If processed as an Idaho Code 58-1306 application, IDL recommends denial of the application for the following reasons and requires the applicant remove the rocks under the pier before June 1st, 2023. Pier, as defined in those numerous dictionaries, does not suggest applicants' proposed use of supporting the ramp during periods of seasonal ramp detachment from the pier as part of the pier or a pier extension. I've never had a request or seen a similar rock structure as part of a fixed pier in over 8 years working in dock permitting. The rock structure underneath the fixed pier does not aid in navigation. It does not aid in the support of watercraft or moorage of a vessel. Applicants can still access the dock and moor a boat on the dock without having the rock structure present, just like thousands of other waterfront owners with the same style of dock. The rock structure more resembles a bank barb, which IDL generally does not permit or allow. The rock structure is a non-navigational encroachment that serves no benefit to the general public via environmental, economic, or social factors. Concludes my statement.
Thank you. Ms. Compton?
Yeah, so I have a couple of citations for you. The more recent one is S Bar Ranch versus Elmore County. 170 Idaho 282. 510 P 3rd 635. That's from this year. And then similarly, Neighbors for a Healthy Pulled Pork versus Valley County. 145 Idaho 121. 176 P 3rd 126. 2007. Those are both Idaho Supreme Court cases. And I apologize for not having that sooner. It's one of those things that sticks in your head, and then when called for a citation, it's not right to be there.
Oh, I appreciate that. I have a couple more questions. I know you've already really, or at least from a high level, discussed the due process argument, but I just wanted to ask a couple more questions. If you could just respond to the assertion about switching applications mid-process.
I can start and
Sure.
then you can. I think that's a respectfully inaccurate way to characterize this. The application was deemed final and accepted on September 15. And the notice appointment of hearing coordinator and scheduling conference went out approximately 2 weeks later, citing 58-13-06. I think Mr. Amer will tell you, and he can certainly correct me if I'm wrong, that it's not unusual for IDL to take a look at, and especially unusual encroachment applications, to take a look at them when they come in and ultimately make a determination about how they best think that something would be processed. And in this case, IDL really determined early on in the process, and again, more than 2.5 months before this hearing, that 58-13-06 was the appropriate way to process this application.
I would add on to that and say that I agree. I don't think there was a switch. There was never discussion with Mr. Wilson where he said, this is definitely a 1305. We're definitely heading to a contested case hearing. Then all of a sudden we just switched it and decided to do something different. He had originally paid $300. The application fee should have been $425. That was oversight on our end, both myself and Ryan not catching that, because that used to be our old fee for those type of applications. He applied for a 1305. And as we're processing it, and I had numerous meetings with Mr. Wilson and Mrs. Wilson, that I felt this was not a 1305. But we cannot reject or deny an application. We have to accept an application. We do not have the ability to just tell somebody, sorry, I don't like your application, go away. We have to accept it. And this is also, again, I said in my statement numerous times, in my 8 years of processing over thousands of applications, this is the first for me. It's the first time I've had something like this.
Thank you. Then one other question. There's an assertion that so back on May 6th, 2021, there's a final report, and it's in one of these different cases, but where you state that the Wilsons have complied with the final order, and they say no issue. You say no issues of concern are identified. Can you just relate that? That's from a different case, and that language to the reasons we're here this afternoon. And if
I believe that language was in relation to the logs and the rocks at the time. I believe, without having it in front of me, I believe our main concern were the additional rocks that were placed along the log structure. And so those logs were removed. So when we go to inspect something and we're going to inspect whether rocks have been removed, and they have been removed, that is what that statement would allude to.
And I can confirm that the final order, so that would be the case we talked about both here today and earlier this morning from the 2020 encroachment permit proceeding. And in that case did not concern the rocks that we're talking about today, the dock, or anything that's sort of at issue in this current proceeding this afternoon. It concerned, as Mr. Amer said, the rocks located closer to Dr. Falloon's property that were placed on top of the log grid. And so when Mike went out and did that inspection and talked about in compliance with the director's final order, that order had to do with those rocks. It had nothing to do with the rocks that are underneath this dock.
Correct. For example, I did not measure the pier. I did not measure the dock and the pier and the ramp to see if it complied with the permit. We were solely focused on the structure on the south of the property boundary.
And then a similar question to what I asked this morning, just based on the objector's legal memorandum.
So there's a request. Let's see. Not just to remove the encroachment, but also mitigate damage. Could you just, again, address what my authority is today?
Yeah, so thank you. And my answer is gonna be, really basically what it was this morning, and I recognize that council and I may have a disagreement in that regard, but. When you talk about, so first of all, let me back up and say this, IDL does often send a letter directing people to remove an unauthorized encroachment, and typically people just simply comply with that, but if need be, IDL can go to court and seek injunctive relief to make that happen. And again, the restoration and mitigation of damages, that requires that they be directed, that in 58-1309, that requires that the party be directed by the court to restore the lake as near as possible to its condition. And again, people sometimes do that voluntarily when there's been some sort of non-compliance issue. But I don't think it's really within the hearing officer's jurisdiction to order that. Same with, and similarly with civil penalties. We have the issue here where IDL is not provided notice, and none of the notices related to this hearing, whether it's the notice of appointment, the notice in scheduling conference, the notice of hearing. They don't provide any notification such as that required by 58-1308 sub 1 to the applicant, providing him with notice that IDL is seeking civil penalties. And then as to the penalties set forth in Idaho Code Section 58-1308 sub 2, that requires a civil enforcement action in district court, which we're not here right now. So those would be my answers to you.
Should I add one more comment to your question to me as well?
Sure, go ahead.
About the switching. I do believe this is a very unusual circumstance because you have an applicant applying for a 1305 who strongly feels it's a 1305, or we feel it's a 1306. If someone were to make application for riprap, which is clearly a 1306, and they were to pay us $425 and say, process this as a 1305 as a doc, it would be black and white. There's no confusion. There'd be no question. We would ask them for additional funds and we process it as a 1306. But this blurs the lines. They truly feel that this is a 1305, and we truly feel it's something different. And again, processing thousands and thousands of applications, this is my first time doing something like this.
Thank you. Well, I think I have one further question, legal question. As far as my authority, do I need to defer to Department of Lands and the director as to whether this is processed as a 305 or 306?
I think in that circumstance, we turn to the Idaho Supreme Court authority in the Simplot decision, and then I think there's been one more recently, and I can get you that citation in a little bit, but it was a JR Simplot company case that talks about an agency's deference or giving deference to an agency's interpretation of the laws that it administers. And in that regard, it's similar to the Chevron deference at the federal level, although Chevron again does not apply here because we're in a state forum rather than a federal forum. So I certainly the hearing officer retains authority to make the ultimate decision in this matter. However, I do think that under those JR Simplot factors, which I'm just recalling them off the top of my head, but it's whether the agency is charged with administering the statutes and rules in question, the reasonableness of whether they have discretion, whether they reach their decision by an exercise of reason. Those sorts of factors I think are applicable here, and it is worth noting that Mr. Amer obviously is quite experienced in interpreting the rules, the statutes and the rules that IDL administers. He deals on a daily basis with navigational versus non-navigational encroachments, and he knows what fits well within each statute. And I think the agency is entitled to deference in that regard.
Anything else?
No, thank you.
Mr. Wilson, you get the final say.
I will begin with Mr. Amber's comments. In terms of your authority, I think your authority issues from the delegation of authority and that notice of appointment. It clearly says that this public hearing will be conducted pursuant to Idaho Code 58-1306, which is an informal public hearing. It doesn't say 1305. It's impossible to do a 1305 decision in this case because the judicial tools of a 1305 hearing are unavailable. Those are the trial-like tools, sworn testimony, direct testimony, cross-examination. Those are unavailable. That's why this cannot be, you cannot decide this as a 1305 action. We're not in that forum. It sounds good, but it just doesn't make any sense. That's the biggest part of the constitutional violation. My ability to defend my property right of using navigational aids has been deprived from me. I can only speak when you ask me to speak. I can't ask him any questions. And I'm defending a property right. So I think it's really clear. This does not permit 1305 hearings. There is a provision in the rules and regulations that says that if IDL makes the determination that it's both a 1305 and a 1306, then you got to bring it within 60 days in this shorter period of time. And if that's the case, well, we missed that date too. So I'm going to start with the observation that in some of the pictures, the ramp remained attached during the winter. There are some times when I can't get to the lake in that 10-day period, October 10th on, to remove the ramp in time. It doesn't happen every year, but some years it does. So there's nothing extraordinary about that. And Mr. Amer stated that the Idaho APA section 20.03.04.0.05 does not contain any mandatory language about publishing things about application. Well, the statute does. 58-1306 in subsection C states when it talks about
What was the Idaho code you referenced again?
1306.
Oh, okay, thank you.
It says at the bottom, the same, speaking about this hearing, shall be held no later than 90 days from the date of filing of the application. That's mandatory statutory language. And I'm pretty skilled at this too. Spent 34 years as a corporate finance investment banking lawyer, mired in the Securities Act of 1933, the Securities Exchange Act of 1934, the Investment Act of 1940. I live in federal statutes and very complicated federal security regulations. I do this, I've done this for 30 years. I know how to analyze a statute as an enabling statute and look at every piece of it. And I find a lot of procedural errors. I find a 14th Amendment violation. Clearly, IDL doesn't have the luxury of choosing which parts of the statute they want to comply with. They simply don't. They're supposed to publish a notice of application. You asked them about it. In my briefing, I make note of that. The October 17th here scheduling conference was not recorded. It was supposed to be recorded. There were some questions asked that I referred to in this. And one of them was your question to Ms. Kelvin, did IDL file a notice of application? And her response was, I don't know, I'll look into it. And then I believe Eric Wilson added in, I think I may have an answer to that question. But we never got that answer. What we got on the 21st of October, 4 days later, was this tortured explanation of why Mr. Amer's decision that he made on or before September 25th somehow constituted the director order exception to publishing the notice of application. So I've gone through that analysis for you. It's not an order. It doesn't meet any definition of an order under Rule 730. So it never happened. That's a fatal flaw in procedural due process. If nothing else. So, you know, both Bill Falloon and Mike Amer have said there are many rocks in front of the pier bulkhead that I'm seeking to permit. And Bill correctly noted I said it's about 6 feet long. That's all I'm trying to permit. The ledge part. Not the other stuff that's beyond. It doesn't serve any function. It doesn't stop the migration of sand. It's 3 feet under the lake. There's no wave breaking action that moves sand in the summer. All wave action that moves sand is at the shore break. Now the inspection report. On April 30th, Mr. Amer and his team came out with both of my permits and looked around. They looked at everything. They looked at the rail system that I permitted in that week, that I commenced in that week. And Mr. Amer looked at these rocks. We stood there together, discussing them for a few minutes. I had begun to disassemble them. Had a big spike out there, and I was trying to break the rocks out. And he says, "What are you doing?" So, well, girls, I'm gonna have to take this out. It's petty. Don't. So when I got the clearance report a few days later, and the box was checked, no other issues, I thought, well, hey, that's great. This is petty. It's not going to be a big deal. So in the course of making the new application that included the new rail ramp system, I drew the rocks adjacent to the ramp. I drew them 3 times. The first revision was rejected. It had rocks over the log crib. I was told to white it out or remove. I did. The second drawing only had 2 logs. I was told to remove it. Third drawing, they were both removed. The rocks were drawn next to the ramp. My current permit, L97S 1081B, shows rocks depicted along the ramp. Permit issued, I recorded it in Motor County. Now, if you're going to say they determined that it was a non-navigational permit, it was, well, if they did it, it's done during the 10-day period after they accepted the navigational permit. I made it clear that this was an amendment to my permit. I have rocks drawn in on that permit. I'm seeking to give a more definitive picture of it because I was told to take it out. And I did that. So, you know, they're arguably permitted right now. In fact, Ms. Kaufman in her October 21st response to you does an analysis of my 2004 permit. She says, I don't see any rocks in the 2004 permit. Well, guess what? They're in the 2021 permit, which is the current permit. She analyzed the wrong permit. Moving on. Mike says that we can put in a wooden sawhorse. Well, when you remove a ramp in the fall, you're in 3 feet of water. Sawhorse would float away. We don't remove it by getting into the water. We lay on the pier. We release the pins on each side, my wife on one and I on the other. And then here we are hanging over with one arm each on either side, trying not to let this thing fall into the water. So move it out a little bit and lower it down. Drop it on the rock. And it's not light. It's about 12 feet long. It's made out of aluminum. It's still heavy. More than anything, it's awkward. You know, maybe it is unique, but it works for us. It doesn't hurt anybody. It sits under the footprint of our navigational permit. You know, Mike and I argued about this. I said, Mike, how can you have a non-navigational permit within the context of a navigational permit Doesn't make any sense. Whether or not there's anything there, the lake bed that you regulate is encumbered over the water. I even think that argument was made in the briefs that were filed in the Newton case. I think somebody at IDL testified that IDL is principally concerned with the footprint of the encroachment. In that case, Newton was complaining that IDL failed to give it notice and they violated his constitutional right to a view because the other person had put a second story on his float house and it impaired his view. And that case determined, well, you don't have a right to it because you don't have a right to access the adjacency of your property through navigational. But I think there was testimony in that we don't care if he goes up because we're only concerned with what goes down. We're concerned about the lake bed. So obviously there's no public benefit, but it certainly helps us a lot. We can't see it. I mean, you see the little bit sticking out at the top. And it only helps us 2 times a year. But that, as we get older, what's wrong with that? It doesn't bother him. Bill wants our beaches to erode because he wants to replace the sand that was lost when he removed his concrete pier. Now, I think completely that demolition in the lake bed is a regulated activity. IDL's not the only group that has authority over the lake. They have concurrent jurisdiction with the Department. The Corps of Engineers, Department of Water Quality, Fish and Game. I mean, there's 4 agencies that oversee that. So there is a section which ends in which is in my brief. It says no demolition activities without a permit. And Mike and I talked about that. He said, well, that's only in the context of a new application. Well, that makes no sense for policy. I mean, if you're going to regulate the lake bed, you should really be concerned about when somebody puts a jackhammer on the lake bed that leaks hydraulic fluid or whatever, if it has that for a hammering effect, you should regulate. So I think they're wrong. I think clearly IDL has not waived their right to regulate demolition activities in the lake. Yeah. If Dr. Falloon had said, you have to have a permit, I would have gotten notice because we were already complaining about the impact that the removal would have on our beaches. And they're adverse. Yet I am the one who's the bad guy here because my little riprap log structure is causing erosion. It's not. It's preventing my beach from further erosion. The erosion we started. As to switching applications in mid-process, I've got a permit that describes the rocks along the ramp. I file another navigational permit to further elaborate or enlarge on it. It's clearly a navigational permit because I've already got rocks in my permit along the ramp. Same rocks that everyone's used for Cigar. That don't exist. And the first time that I found out about the fact that this was going to be under 1306, I objected as soon as I could. Because there may not have been specific discussions citing the statutes when we met with Mike on the 21st of September. But there was absolutely discussion about the navigational permit. And I cited to him the most unusual circumstances in 1305. So I think that's pretty clear what we're talking about. And this is a violation of the proper methodologies to process my application. I claim a right in the rocks because they're permitted. I claim a right to have my application reviewed as a navigational permit because of that. There was never an objection between the time I filed the application and the time Mr. Amer says he got a hold of it after it was completed, that anybody ever said anything to me about treating it as a non-navigational application. Mr. Amer did say in our meeting, he thought it looked like a navigational structure. I said, fine, argue most unusual circumstances, I'm ready for that. That's where we should be. We're not. I have lots of reasons to have to claim that I'm rightfully due processing under 1305C. I want to talk about Ms. Calvin's comments. Due process is about news. And that new case, and the other one that they cited, stands for the proposition that when I file a navigational permit in the state of Idaho, I'm entitled to certain processes. And I believe that I was entitled to those processes because I was attempting to amend my navigational permit that contains rocks drawn in along the ramp. And by switching me from a 1305C process, the 1306C process, they altered the statutory processing. And new stands for the proposition of you got to find a protected property interest first, or you analyze what the process is. And in this case, the protected property right is under the Lake Protection Act. I have a protected property right as a littoral owner and accessing the adjacencies of my ownership by the use of navigational aids. And that's exactly what I have, and that's what I'm trying to do. And then you evaluate what is the process. The process is 1305C. Because I should be entitled to defend my property rights in an adversarial proceeding with the judicial tools, taking testimony under oath, cross-examination. I don't have that right. I'm defending a property right in a public hearing where I'm stripped of my constitutional defense tools. That's wrong. And then I think I would object to Ms. Kaufman's statement that the rocks are on public trust lands. We don't know that. She doesn't know that. They don't know where their jurisdiction begins and my ownership begins. So I would ignore that. Missing notice of the application is really, really relevant. It's part of the due process protection to notice. The public has a right to notice of the application. The public has a right to notice of the hearing. Both are supposed to be published. In fact, when you assert that you have a director-initiated order of a hearing, their guidance document states they file both the notice of the application and the notice of hearing. You file both because you don't get to pick and choose. Now, the statute doesn't say that, but the guidance document is Ideal's interpretation of the law. And I think that's reasonable because of the argument I'm making. If you only do one, the statute says you're supposed to do two, but you have some weakness. The idea of that guidance document is to make staff follow the rules and regulations so they don't inadvertently violate somebody's constitutional right due process. Those are all due process protections. Ms. Kaufman said that there was information lacking on my objections. In other words, I was at the scheduling conference, and by participating in the scheduling conference, I've somehow waived my rights to argue this hearing should have been within days, not 94 days. I had expected, as it was, we were informed that that scheduling conference would be recorded. And when we met again on November 7th, you informed me that it hadn't been recorded. There was apparently some recording error. So my objections weren't recorded. There's no record of it. So I immediately filed restatement of things the following day. I used my talking points from the 17th. And I go through this, that on October 17th, I revoked and retracted any no waivers. I offered no waivers. I offered no consents. I reserved all rights in this matter. So you can't say because I submitted myself to this improperly called hearing that I waived. I made very clear I didn't waive anything. So I knew this was going to be the response. I got savvy. And when Ms. Kaufman mentions that, we were going back and forth in September with Ms. Romine about setting a hearing date, I was under the impression the whole time that was a 1305 hearing with a 60-day con clock. And I didn't have, the application was accepted on the 15th. I had until November 15th to get all my things put together. And I spent a week trying to find a geomorphologist about this sand under 3 feet of water. Well, that's pretty darn hard to hire a geoscientist within a year. I called firms all over the United States and in British Columbia. Nobody's available for me. So that was pretty awful. I talked to a couple of engineers, one in Florida and a friend of mine. Hey, they could do it sooner, but they're engineers. They're not experts in the movement of sand and gravel, and beach fronts or lake fronts. So when I said I didn't know I was available because I really thought I was under 1305 and the time to prepare. You can't prepare that kind of a defense in 45 days. Now I'm going to move on to my comments onto Bill's comments. So he talks about this little structure in front of the pier bulkhead is preventing the movement of sand. I've lived here for 20 years, 5 of them full time. Sand doesn't move under 3 feet of water. It just doesn't move. There's no wave action. For the most part, the waves are protected by my floating dock. And when the waves do come, they hit the bulkhead of the pier. You don't go down 3 feet and move sand. So it's minimal. Now I want to move back to the application. Everybody's saying, well, look, it's 12 feet long. The application only asks for 6 feet because that's all I need for this ledge. That's why I started to pull some of this stuff out to reduce the front side of it. So it's not like I'm asking for less than is there because I am willing to take it out. But if there's this constitutional violation, a violation of all this notice, this hearing is void. It has no authority. And I fall back to the 1305 G. Didn't process me within 60 days. Applications being approved as a matter of law. And again, the picture of FH showing this concrete wall and rocks. Exhibit O outlines what I and my son installed on or about 2012 in front of the pier bulkhead. Bill's description of a concrete wall and rocks, that's been there ever since that pier's been there. Is that way when you bought the property? And the photograph that he showed you F11 as proof it was never there, it's too dark. You can't see it. And there's a boat lifting. It was there. I make the statement in my declaration under penalty of perjury. That's a true statement. Yeah, I've been a member of the Idaho Bar for 34 years in good standing. I would never, ever intentionally be untruthful. It's like I tell my children growing up, never lie. You have to either lie, you either tell the truth or remain silent. Let people infer what they want from your silence. It's like Abe Lincoln said, it's better to be silent and thought a fool than to speak and remove all doubt. Again, Bill's discussion on my 2004 permit is irrelevant. It was superseded by the 2021 permit. I didn't draw that initial permit. Copper Bay built the dock. Like I said, I don't know anything about the Lake Protection Act right up until 2018. So anything I did before that was in ignorance. Lawyers don't know everything. Smart ones know when to say that when they are ignorant. I was ignorant. Again, we have to make a distinction between natural high water mark, ordinary high water mark, and artificial high water mark. They're words of art. They mean different things. The natural high water mark is the 1890 level when Idaho became a state and nobody really knows where it is. The ordinary high water mark is commonly referred to as the summer pool, but it's more correctly referred to as the artificial high water mark because of the influence of the dam that was installed in recycling. So IDL's got the authority to do anything they want in terms of regulation for artificial high water mark, or bottom of the lake. And I think the Hudson case stands for that pretty clearly. Bill said my ramp is like, Bill has never picked up. Bill says I don't use the rock ledge, but Bill goes away pretty much between the 1st and the 30th of September. He's a seasonal part-time writer. So I dispute that. And he says we don't get into the water. I mean, he puts on waders and goes into the water with his girlfriend and removes his ramp. They have a hard time. It's tough. His is quite a bit shorter than ours. So perhaps he will have a remake. He came over and we helped him and told him, you know, who made ours, what the material was, because he struggles with this too. I mean, they're out there soaking wet, you know, in 35-degree water in the spring. I don't want to do that. I want to put mine on the rock ledge and stay out of it. I don't have waders that would work for that. And in regard to Bill's orthopedic skills, you know, like commenting on my physical abilities. He's not my doctor, he's never been. He doesn't know anything about my history. We watch each other, you know, we can see he's got some problems with his body, you know, being a tall guy. I got some problems with my body being a tall guy. He's 60 something, I'm 71, close to 72. We're just human. We're just trying to live in peace, you know, and not have any trouble with it. We're nice to everyone. It's who we are. And I don't like this. I feel like I've been attacked. You know, he wants my beach. Okay, hey, look, let's go do some battle. See he wins. But these procedural irregularities are devastating to Idaho's case. They violate statutes. They violate the US Constitution. And I'm going to stand really hard and firm on this. And I'll take it to the win. I don't want to. Like Bill says, it becomes easy to me because I'm a lawyer. Well, Bill, I've spent 80 hours on this.
It's been a lot more than that.
Okay. We've all been courteous so far.
Sorry.
So I don't, that's,
I'm sorry.
those are the end of my comments. Let's go.
Can I put one citation of authority on the record? I know it might open things up again, but this due process thing, I have some authority that I think might be helpful.
I really, in this informal proceeding, you had your chance to comment, so I can't do it. I know I was like,
But it addresses something I'd never heard before. It's something that he just said now.
I know he gets the last word. He's the verge of it. So I'm not gonna allow it this afternoon.
If I need to supplement the record with authority that,
Well,
given that this is going up on appeal, apparently. and he's gonna
well, you
file-
do raise a good point. If you want to write down right now, I'm only taking written comments in this hearing. If you want to write down the authority and we'll submit it as a written comment, I will allow that. I guess that sounds silly, but go ahead and do that. And then I will give you a chance to look at the written comment. And then if you need to still have final rebuttal, you have to do that. So we're going to add that as document 17 to the record.
I want to make sure I get it right, sorry.
Sure, take your time.
Did you want me to show the applicant before I hand it out?
Go ahead, I'll go ahead and read it. So the public comment is due process is not a concept to apply particularly in every matter, rather than a flexible conceptual
I'm sorry.
concept
Flexible concept calling.
of calling for procedural protections as warranted by the particular situation. Floyd versus Board of Ada County, 164 Idaho 659 from 2019. So I'm going to add this to the record as a written comment 17. Do you have any further comment you'd like to make?
No, but I'm not. Today. I will,
Oh, I-
if I could get a copy of that.
yeah, it's going to go in the record. So
Then I will respond timely. It's okay.
okay. And it is 3:20. So this time I'm going to end the hearing. Yeah, thank you again, everyone, for your participation. We're adjourned and you can stop recording.
Thank you.
Thank you,
everyone.
hearing officer. I've stopped recording.